The Criminal Law Temporary Provisions Act 1955 was last extended in 2018 for 5 years, till 20 October 2024. The Act is a critical piece of legislation for us to deal with egregious criminal activities which threaten the sense of safety and security in Singapore, in particular, the activities of gangs and secret societies. This bill seeks to extend the Act for another 5 years. Under the Act, the Minister for Home Affairs may detain or place under police supervision persons associated with activities of a criminal nature. These activities are set out in the 4th Schedule of the Act and include involvement in a secret society or as a gangster. The power to detain someone under the Act is used only when prosecution is not viable, for example, because victims and witnesses refuse to testify for fear of reprisal. We have put in place safeguards in the exercise of these powers. First, the consent of the public prosecutor must be obtained for a detention order or supervision order. He must be satisfied that prosecution is not viable before allowing executive action under the Act. Second, we have 3 committees that are independent of MHA to ensure that detentions are necessary in the interest of public safety, peace, and good order. The first committee scrutinizes every detention and supervision order issued by the Minister. It is chaired by a sitting judge of the Supreme Court and comprises senior and experienced lawyers. It examines the evidence that was considered by the Minister in issuing the order and submits its report to the President to recommend the confirmation, variation, or cancellation of the order. A second committee considers every confirmed detention order at least once annually. It will consider whether the detainee continues to pose a threat to public safety, peace, and good order, and whether the detainee should continue to be detained or released. A third committee reviews detention cases which are being considered for extension beyond 10 years to determine if continued detention is indeed necessary. They are required to submit a report to the President, who may, on the advice of the Cabinet, confirm, vary, or cancel the order made by the Minister. Third, detainees are required to attend in person before the first committee, when the committee considers the order made by the Minister. Detainees can be represented by lawyers and may make representations to the various committees. Fourth, every decision made under the Act can be subject to judicial review